Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance, argument by argument, judgment by judgment. It was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments. Welcome to the history of our rights. Welcome everyone to this very special first episode of Shaping Canada, 150 Years of Landmark Decision, a podcast dedicated to exploring the impact of the Supreme Court of Canada on our society. I am Hugo Martin.
And I'm Laurence Laperrière. Hugo, this year is certainly not insignificant.
Indeed, 2025 marks the 150th anniversary of the Supreme Court of Canada, a century and a half of existence for a fundamental institution of our democracy. It is to mark this event that we are launching this series.
Exactly. And like any good piece of legislation or contract, we wanted to start with some preliminary provisions. This episode aims to set the stage to introduce you to this institution before we dive, in future episodes, into the heart of the decisions that have shaped Canada.
So let's start at the beginning. 150 years takes us back to 1875. Why create a Supreme Court at that particular time?
Good question, Hugo. The Constitution Act of 1867 had given the brand new federal parliament the power to create a General Court of Appeal for Canada.
But Laurence, what happened between 1867 and 1875?
Let's set the context. Canada was a young country born from Confederation in 1867. There was a desire for national assertion to develop Canada's own institutions. But there was also a practical need to harmonize the interpretation of federal laws across the provinces, which had their own legal traditions. There were debates in Parliament about the necessity and form of this court. Some feared it would encroach on provincial powers or become too powerful.
Thanks for clarifying. The idea was to have a national jurisdiction to standardize certain interpretations of the law, even though, at the time, this newly created court wasn't yet the court of last resort.
Yes, the famous Judicial Committee of the Privy Council in London. That legal body truly had the final say back then.
So it wasn't until 1933 that the Supreme Court became the final court of appeal for criminal matters, and in 1949 for all other cases. So 1949 is when we can really talk about the complete independence of the Canadian judicial system at its highest level.
Absolutely, but the court doesn't just decide disputes. It also has an important advisory role through the reference procedure. The federal government can ask for its opinion on major legal questions, often related to the constitutionality of laws or the division of powers.
As for the reference procedure, we obviously think of the Patriation Reference in 1981, or closer to home for Quebecers, the Quebec Secession Reference in 1998. Moments where the court played a crucial role in defining the country itself.
Definitely. And who sits on this court? In the beginning, in 1875, there were 6 judges. It increased to 7 in 1927, and finally to 9 in 1949, a number that has remained stable ever since.
And Laurence, these 9 judges, they don't always sit together.
The quorum is 5 judges. That's the minimum required. But most of the time, especially for important constitutional cases, 7 or even all 9 judges hear the appeal. The Chief Justice presides, sitting in the center, and the other judges sit to the right and left in order of seniority of appointment.
The 9 judges work very collegially, despite sometimes diverging opinions. Deliberations after the hearing are secret and crucial. The Chief Justice currently the Right Honorable Richard Wagner, besides presiding over the court, has a significant administrative role. He's somewhat like the CEO of the court, its spokesperson, and he also represents the Canadian judiciary nationally and internationally.
And how does one become a Supreme Court judge?
Well, the process has evolved, but today they are appointed by the Governor General on the recommendation of the Prime Minister after consultation with an independent advisory committee composed notably of jurists.
The eligibility criteria are also specific. One must have been a judge of a provincial superior court or a lawyer who has been a member of the bar for at least 10 years. And there's a key rule for Quebec.
Yes, the Supreme Court Act guarantees at least 3 of the 9 judges must come from the bar or the superior judiciary of Quebec to ensure representation of the civil law tradition.
That's one of the court's unique features. It's bilingual, but also bijural. It must master and apply both common law, which prevails in most of Canada, and Quebec's civil law. That's unique in the world for a court of last resort.
Yes, Laurence, the bilingual and bijural character is fundamental. For our listeners less familiar, let's briefly recall the major differences between civil law in Quebec, inherited from France, codified, and common law in the other provinces, based on judicial precedents inherited from England.
Managing these two systems, often in both official languages within the same case, requires incredible expertise from the judges and qualified staff. The judges must be able to navigate between these traditions, understanding their distinct logics. It's a constant challenge, but essential to Canada's nature.
Indeed, Laurence, we mentioned the 3 judges who must come from Quebec. For the other 6 positions, convention dictates that there are 3 judges from Ontario, 2 from the Western provinces, including the territories, and 1 from the Atlantic provinces. An important regional balance, and these judges are appointed until they retire or reach the age of 75.
Now let's talk about what the court does day to day. How do cases get there? There are 3 main paths.
Yes, there are. The most common is seeking leave to appeal. It's a request by one of the parties to the Supreme Court asking to be heard. They need to convince the court that their case raises an issue of public importance or a novel question of law. What does that mean in practice? Well, it could be a new legal question that has never been decided, conflicting interpretations among provincial courts of appeal that need unification, a case affecting a large number of Canadians, or, of course, fundamental questions related to the Constitution or the Charter of Rights and Freedoms. The court selects cases where it believes it can make the most significant contribution to the development of Canadian law.
In addition to leave to appeal, there are appeals as of right, which are rarer and provided for directly by law in specific circumstances, often in criminal matters.
And the third path, we mentioned it already, is the reference procedure, where the government asks for a legal opinion.
And once a case is before the court, how does it work? It's important to remember that the Supreme Court doesn't conduct new trials. It doesn't hear witnesses or accept new evidence.
Exactly. The judges rely on the record from the lower courts, the written arguments of the lawyers, the factums, and oral arguments. It's during these hearings, which are public and now often webcast, that the judges ask lawyers many questions to test their arguments.
With exceptions like publication bans or closed hearings in sensitive cases, transparency is the principle. Moreover, the court makes significant efforts to be accessible.
Yes, it publishes plain language summaries of decisions, the cases in brief. There are guided tours, school programs, and the judges actively participate in conferences and meet with students.
The court has even held hearings outside of Ottawa, in Winnipeg in 2019 and Quebec City in 2022 to connect with citizens. And this year, in 2025, the judges have visited 5 communities across Canada: Victoria, Moncton, and then Yellowknife, Sherbrooke, and Thunder Bay. These visits are an opportunity for the public, students, journalists, and the legal and judicial communities to engage with members of the court.
Laurence, we are talking about an institution that is 150 years old. But it's not frozen in time, it evolves, just like the society it serves.
That's true. We've seen it recently with historic appointments. Since the appointment of Justice Mary Morrow in 2023, the court has a female majority for the first time.
There was also the appointment of Justice Jamal in 2021, the first judge of color, and Justice Michelle Obanzawin in 2022, the first Indigenous judge to sit on the Supreme Court. Important steps for representation.
Yes, even the court's symbols were modernized in 2021 with new armorial bearings. They feature strong elements. The vertical red bands symbolizing bilingualism, bijuralism, and Indigenous contributions, recalling the two-row wampum belt. The central lozenge, representing the 9 judges and the court's role. The royal crown. And the motto Justitia and Veritas, justice and truth.
Statues of Justice and Truth are also located right in front of the court's building in Ottawa, an iconic building on Wellington Street where the court moved in 1946 after occupying premises in Parliament and then in another building. It will now move temporarily for renovations.
Besides that, Hugo, the current building is more than just an administrative building. It's the work of Montreal architect Ernest Cormier, a major figure. His Art Deco style, the quality of materials, the symbolic details, even the Justice and Truth statues were designed by him.
Having been there multiple times myself, you find a grand, impressive courtroom, but also one of the country's most important law libraries, a place steeped in history and symbolism.
A solid institution, rooted in history, but resolutely forward-looking and aware of its role. The 150th anniversary theme says it well. 150 years upholding the rule of law, inspiring public confidence, and serving the community.
And that is exactly what our podcast series will explore in the coming months. After these preliminary provisions, we'll dive into the heart of the matter.
In the upcoming episodes, we'll dissect landmark decisions, ruling that have had a tangible impact on the lives of Canadians, that have shaped our society. We'll talk about constitutional law, the Charter of Rights and Freedoms, Indigenous peoples' rights, criminal law, and much more.
And when we talk about landmark decisions, expect fascinating deep dives. We will explore how the Charter of Rights and Freedom,
adopted in 1982,
yes, how it came to life and transformed the legal landscape through the court's interpretation.
Think freedom of expression, the right to equality, the rights of the accused.
We will also delve into the complex and ongoing evolution of the rights of Indigenous peoples recognized in the Constitution and how the court has attempted to define and protect these ancestral and treaty rights.
All that without forgetting family law, administrative law, and of course, the unique impact of decisions on the division of powers between Ottawa and the provinces, an ever-present issue. And all punctuated by the unique perspectives of the current justices on this legacy.
Yes, Laurence, you're right to mention it. We will have absolutely exceptional access. I am extremely happy and honored to announce that all 9 currently sitting judges of the Supreme Court will participate in our series.
What does that mean specifically for our listeners?
Well, it means that we will hear directly from each of the 9 judges about decisions that, in their view, have had a significant impact on Canadian society over the past 150 years. They're jurisprudential favorites, if you will. A unique and personal perspective on our country's legal history.
Getting the judge's own views on the court's legacy is truly a privilege. That promises fascinating discussions.
Absolutely, and it will be a common thread throughout the series. Whether you're a lawyer, a student, a citizen curious about how major justice decisions influence our daily lives, Shaping Canada, 150 Years of Landmark Decisions is for you.
We hope this preliminary provisions episode has given you a good overview of the Supreme Court of Canada and made you eager to learn more. It's a special preview released to properly mark its 150th anniversary.
The full series, including our in-depth analysis of major decisions and, of course, our exclusive interviews with all 9 judges of the court, will follow. By subscribing to Shaping Canada, you will be the first to know about the launch of each episode.
Exactly. Subscribing to Shaping Canada on your favorite podcast platform is the best guarantee not to miss the official launch of the full series. You can also visit the shaping-canada.ca website where we'll share news about the project.
And why not extend the reflection right now? What Supreme Court decisions do you think have most shaped the Canada we know today? We'd be curious to read your ideas. Share them in the comments on social media with the hashtag SCC150podcast, or in the comments for this episode, or via info@rivercastmedia.com.
Thank you so much for joining us for this special 150th anniversary episode. Please share it with others. We look forward to commemorate with you for the grand premiere of Shaping Canada, 150 Years of Landmark Decisions.
Until then, take care and stay curious.